Today we are talking about something that could change the outcome of your green card case even if you have never broken a single immigration law. The public charge rule is back, and this time it is broader than before. Starting September 18, 2026, using Medicaid, food stamps, or housing assistance could now be counted against you when you apply for a green card. Families who thought they were doing everything right could suddenly find themselves facing a denial. So, who exactly is affected, and what should you do before that date arrives? If you are interested in this topic and liking this video, please stay tuned until end of the video. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. In a recent development, the Department of Homeland Security announced on July 16, 2026, that it is reviving a stricter version of the public charge rule. This rule officially took effect on July 20th, and the enforcement date, the day it actually starts applying to new applications, is September 18, 2026. For those who are not familiar with the term, public charge refers to a legal standard under Section 212 of the Immigration and Nationality Act. It allows immigration officers to deny a green card if they believe an applicant is likely to become primarily dependent on government support in the future. Here's what you need to know about what existed before. Under the 2022 rule put in place during the Biden administration, officers could only count direct cash assistance, things like supplemental security income and temporary assistance for needy families, along with long-term institutional care paid for by the government. Everyday support like food stamps, known officially as the Supplemental Nutrition Assistance Program, or SNAP, along with most forms of Medicaid and housing vouchers, were considered safe. A family receiving grocery help while working full-time did not have to worry about their green card case. That protection is now gone. Under the new rule, immigration officers have the authority to weigh SNAP, most Medicaid coverage, and housing assistance such as Section 8 vouchers as negative factors. Officials argue that this change restores what they describe as the original intent of self-sufficiency requirements in immigration law, aligning with Congress's long-standing goal that new residents should not become a permanent burden on public resources. Immigration experts note that the new rule goes even further than the version used during the first Trump administration back in 2019 because it does not publish a fixed list of which benefits count. Instead, officers apply what is called a totality of the circumstances test, meaning they look at every factor together rather than making a decision based on one single issue. So who is affected by this change? The following categories are under review. Family-based green card applicants filing Form I-485, the application to register permanent residence or adjust status, especially those with lower income or a history of unemployment. Employment-based applicants whose sponsoring employer offers modest wages relative to family size. Immigrants applying through consular processing outside the United States, since the Department of State follows related but separate guidance. And dependents within a household, because a spouse or child's use of Medicaid or food assistance can factor into the primary applicant's case as well. According to sources, elderly applicants and those with chronic health conditions may also face additional scrutiny, since officers can now consider health status as one factor among many. Let's take a closer look at a real-world style example. Imagine a parent who works full-time and pays most of the family's bills, but the household also receives food stamps to help cover groceries each month. Before September 18th, this parent would be considered safe because their job is their main source of support and the food assistance is just extra help. Starting September 18th, an officer can now weigh those food stamps as part of the overall decision, even though the parent is working and largely self-supporting. That is the real shift here. It is not that a single benefit automatically disqualifies someone. Rather, it lowers the bar for how much public benefit use can start counting against an application. Beyond individual benefit categories, the administration has also revised Form Y-485 itself to collect more detailed information about benefit history and household finances. This means applicants should expect more paperwork and potentially more requests for evidence, often called RFEs, where USCIS asks for additional documentation before making a decision. Legal analysts suggest that processing times could stretch further as officers take on this more detailed review process. Currently, some family-based cases already take 14 to 16 months, and that number could grow as adjudicators apply this new discretionary standard. However, before jumping to conclusions, it is important to understand that receiving public benefits does not automatically mean your green card will be denied. As mentioned, USCIS applies a totality of the circumstances test. This means officers are supposed to weigh age, health, family size, financial assets, education, and skills all together, not just benefit usage alone. Despite these broader powers, officers must still consider positive factors like a stable job offer, an affidavit of support from a sponsor, or a strong educational background. While there have been some modifications creating real new risks, this is not a blanket ban on anyone who has ever needed help. One critical detail that every viewer needs to understand is timing. The filing date determines which rule applies to your case. If you submit your Form I-485 before September 18, 2026, your case will still be evaluated under the current more limited 2022 framework. If you file on or after that date, the broader rule applies, and any qualifying benefits received will factor into the decision. This has led many immigration attorneys to advise clients who are close to being ready to file as soon as possible, rather than waiting. Advocacy groups warn that this change could have a chilling effect, meaning families may stop using benefits they are legally entitled to, even benefits that would not ultimately affect their case, simply out of fear and confusion. Public health researchers have raised similar concerns in the past, noting that this kind of chilling effect can lead families to forego necessary health care or nutrition assistance for children who may not even be subject to the public charge test themselves, since many benefits used by U.S. citizen children in a household are treated differently. As a green card applicant or family member, this situation might feel overwhelming, and that reaction is completely understandable. Despite these challenges, there are practical paths forward. If you are currently receiving Medicaid, SNAP, or housing assistance and you have not yet filed, speak with a qualified immigration attorney about your options and your timeline. Start gathering financial documentation now, including tax returns, pay stubs, and proof of assets, since strong financial evidence can help balance out any benefit usage in the totality of circumstances review. If your case involves consular processing abroad, remember that the Department of State applies its own version of this policy, so guidance may differ slightly from USCIS adjustment of status cases handled inside the United States. And do not assume that a spouse or child's past benefit use automatically dooms your case. Every situation is evaluated individually. It remains to be seen how consistently individual officers will apply this discretionary standard, and legal challenges are already expected, similar to the lawsuits that followed the 2019 version of this rule. Many fear that inconsistent enforcement could create confusion even among officers themselves in the early months after September 18th. To summarize, the public charge rule is returning in a broader form starting September 18, 2026, and it will allow officers to weigh the use of Medicaid, food stamps, and housing assistance as negative factors in green card decisions. Filing before that date keeps you under the current, more limited rule. Filing after means facing a more detailed, discretionary review. The good news is, this is not an automatic denial trigger, and strong documentation, legal guidance, and early preparation can make a real difference. Staying informed right now is the single best thing you can do to protect your immigration journey. That's all we have for this bulletin. The Immigration Update channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. Immigration Update videos.